Hello, everyone. My name is Saurabh Kohli with the Aspen Institute's Financial Security Program. Thank you for joining us this afternoon for our event, How Unpaid Bills End Up in Court, the Rise in Debt Collection Litigation and What States Can Do. The artwork we are presenting right now is from the Debt Collectors series, which tells the story of the debt industry and the lives it has impacted. In 2018, nearly 71 million US adults had a debt turned over to private debt collection. Among those who were taken to court, less than 10% had legal representation. Drawing its inspiration from Jacob Lawrence's Migration series from 1940 to 1941, the paintings and the captions document the transformation of the debt industry, its alliance with the courts, and the day-to-day presence of debt collection in the lives of the truly disadvantaged. The Debt Collector series maintains Lawrence's bold color patches, partially illuminated spaces, and explicit links to sociological, anthropological, legal, literary, and ethnographic sources. The Debt Collector series was conceptualized by one of our panelists today, Professor Frederick F. Wary, the Townsend Martin, class of 1917 professor of sociology at Princeton. The series was collaboratively re-envisioned with the artists Ari Riggins, class of 2023, and Rachel McCraich, class of 2021, and with the Visi Lab. As a part of the Debt Collection Lab, the series is an open-ended endeavor that will recruit poets and other artists to add and to deepen the stories told. We sincerely thank Professor Wary and the rest of the collaborative for allowing us to share this artwork to help set the stage for our conversation today. The Aspen Institute Financial Security Program recently published a report, A Financial Security Threat in the Courtroom, how federal and state policymakers can make debt collection litigation safer and fairer for everyone. This report is a simple, non-technical explanation of the litigation process and the real impacts it has on the lives of people across America. We decided to take this deep look specifically at debt collection lawsuits at the urging of leaders and advocates like our partners at Pew Charitable Trust's Court Modernization Project, and reflecting on everything that we have learned about the heavy burden of household debt on communities of color, particularly Black households, through our partners at the Southern Partnership to Reduce Debt. While there have been many deep experts on this topic, many of whom are lawyers like Pew, the National Consumer Law Center, legal aid lawyers, and other advocates, as non-legal experts who look deeply at financial security issues, we wanted to add our voice to the chorus to help shine a spotlight on this major household issue and lift up potential solutions that can have a major financial security impact. Today, we have organized a deep conversation with some amazing experts on this topic. We have Devon Bodie, Community Development Associate with the Federal Reserve Bank of New York. We have the Honorable Alex McVeigh from Hamilton County in Tennessee, who sits as a General Sessions Court judge. Erica Rickard, Project Director of the Civil Legal System Modernization Project at the Pew Charitable Trusts. And Professor Frederick F. Wary, Townsend Martin, class of 1917, Professor of Sociology at Princeton University. Soon I will be inviting the panelists on stage, and just so everyone knows, as agreed upon by the speakers, we'll be keeping the conversation at a first name basis during this discussion. We'd like to thank our panelists for their participation today and their great work in this area. We'd also like to thank the Annie Casey Foundation for their support and the Pew Charitable Trust for helping co-host this event. And we're thrilled that so many of you have joined us today. In the audience, we have a diverse array of leaders, including people who are enmeshed in the court systems across the country. We have state and federal policymakers, and we have other stakeholders like bankers, asset managers, and folks from the financial inclusion space, who we believe also have an important role to play here. We hope you glean something from today's conversation. During the webinar today, please feel free to share your questions using the Q&A function in Zoom. We'll do our best to address your questions or follow up. Please feel free to use the chat to share any thoughts, any resources, and to introduce yourself to the fellow participants. And if you have any technical difficulties, please also post those in the chat. Our team will be on standby to help resolve any technical issues. Now, I'd like to invite our panelists to turn on their cameras and to join us. Hi there, Fred. Hey, Devon, Erica, and Alex. Thank you all so much for joining us. Um, First, I'd like to start off with Fred. Thank you so much for granting us permission to display some of the powerful art from the Debt Collector series. I was wondering, could you share more about these works and why you believe art and storytelling can help change the narrative around debt?
Yes, and so one of the things that we sometimes forget is that it's through art that we are able to approach someone else's experiences in ways that we might not be able to otherwise. It's also a way that we might reapproach our own understandings. And so one of the things that I think is really important as we move forward is that we change the way we're talking about debtors and how they get into the situations they're in, and that we bring sort of a more full understanding of what happens at the moment of debt collection and what are those things that we as a society should find abhorrent. And so thank you for sort of highlighting that art piece, because that's closely tied to our data collection efforts.
Wonderful. And do you mind, I've heard you say during the process of debt collection, individuals learn that they can be treated as if they have no right to respect or redress. Could you help provide some more color there and explain what the debt collection process can be like for many?
Yes. Yeah. So one of the things that I spent some time doing with my team is we just went through the complaints database at the Consumer Financial Protection Bureau. And there you have some really wonderful narratives that are submitted by consumers. And you find that debt collection is both personally troubling, but also professionally perilous. And so personally, there's the story of the woman. She's in her car, her daughter's in the passenger seat. She has her phone on speaker, and a debt collector is on the phone threatening to send a sheriff to her house, using lots of profanity. And what this mother adds in the complaint is it made her daughter cry. And so many of us cannot sort of envision some kind of service encounter in which our children are crying and we've been berated, or the person who talks about his uncle who will no longer speak to him because of all the debt collection calls, because now the uncle is getting calls as a cosigner, and the uncle is retired and now has that sort of retirement security threatened. But on a professional level, we see people getting called at work. And so there are a number of people who wrote in and talked about, I'm getting the talk from my boss about all these harassing phone calls that are coming into work. And so for people who may be already worried about whether or not they're going to be able to keep their jobs or have opportunities for promotion in their jobs, this is a professional peril. And so sometimes we kind of forget that by virtue of not being able to pay, debt collectors do things that make it harder for people to both pay and to maintain some kind of security for themselves and their families.
Gotcha. Thank you so much for sharing that piece around potential relational damage, but also the professional implications. Devon, I would love to turn to you next to help situate the audience a little bit more around the function of debts and the dual function of, in some ways being able to help folks build financial security, but there are also debts that can undermine financial security. Could you share a little bit more about how debts can be harmful for households and consumers?
Certainly, Saurabh. And first, I do have to give a quick disclaimer. The views that I express are my own, and I do not represent the Federal Reserve of New York or the Federal Reserve System. And I just think this discussion, this conversation is very important, because what I do is study how debt and how wealth interacts with households. And really, it's just a tenet in my work that all households should be able to participate in our economy and to thrive in our economy. And really, generating wealth is almost impossible when families can't meet their financial obligations and when they're spending large portions of money and time servicing debt. And there are many debts that penalize households, as you heard from Fred, and that can trap households in just a cycle of debt that leads to fees, that leads to collections and even bankruptcy. And you'll hear more about that later in the conversation. But I think the paper is really important in highlighting these issues because it highlights one of the first things that I think is important to highlight is that not all people experience the negative consequences of debt. The Fed collects great data on liabilities. You look at the survey of consumer finances, you see that debt in America is quite ubiquitous. It is everywhere. About 77% of households have debt, with the majority being mortgage debt. Very obviously, housing is very important to the American economy. And some people are able to leverage debt with a lot of success, but many people don't. And those are the people that I like to study and that I like to see how debt really interacts with them and their lives and their livelihood. And really, when it comes to the issue of debt, our conversation isn't only just about the sheer amount. It's about which debts are people holding, because there's a vast array, some that are good for households, some that aren't necessarily so good. And then how do those debts compare to a household's income or a household's net worth? And, if you've been here in America for the past couple of decades or however long, you know that, overall racial, gender, and class disparities really all play a role in how households interact with debt. I think that's an important thing to point out. And there are three ways that I think debt really negatively interacts and can harm households, especially those that are low income, especially households of color. And the first is that with debt comes trade-offs. Households often come with have to make the decision of, should I pay this overdue medical bill, or should I pay my utilities, or should I pay for basic needs in order to pay off this collection that is coming against me? And a well-cited 2019 survey of household economic status that about 57% of people who had outstanding medical bills in 2019 reported that they could not cover their monthly bills or would have difficulty doing so when faced with an unexpected expense of $400. So that was a stat that was widely shared that really resonated with a lot of people. The second is that debt makes it hard for families to save, to build wealth, especially when we're talking about the interest and the fees that are taxed on top of the principal amount. In 2020, there was a study that found that medical debt was associated with 69% lower emergency savings balances and 26% lower retirement saving balances. So this really has long-term consequences if a household cannot adequately manage their debt or the debt becomes very penalizing to a household. And then lastly, I'll say that debt just makes it harder to manage financial emergencies, financial shocks, going again to that $400 expense that households said that they could not pay. It makes it harder for households to build credit because debt is well linked to credit scores and how people deem our credit worthiness to plan for the future. And something that I think is not talked enough about is that debt is very linked with anxiety and depression and mental health. There's a couple of studies that have been able to show this. Individuals with high debt to asset ratios had higher levels of stress and depression, according to the NIH. And there's also a meta study that I like to bring out as well, a meta-analysis that was done in 2010 that looked at a range of 60 papers that really confirmed a relationship between debt and mental health, showing linkages to suicide completion, to drug and alcohol abuse, to negative health outcomes. So it's not even just about financial standing, it's about how people are thriving in their livelihood. So it's an important conversation to have.
Thank you so much for sharing that really important context. Much appreciated. Cool. I'd like to go to Alex next. And Alex, if you could describe the role you're in and to help explain for the audience, how can a bill end up in court? How can somebody get sued over a bill?
Again, I greatly appreciate Aspen and welcoming me to the program. A little bit about, I guess, the court system, and I'm not going to, rehash the very good Section 3 Aspen's white paper on the subject, kind of describing the process about how a bill becomes, off the old Schoolhouse Rock song, how a bill becomes a lawsuit. And so I'm not going to get into just repeat all those details because you guys do a good job of describing it, but I'll hit some of the high points. But really what I think the title, how a bill becomes a lawsuit, is a little more generous. I spent the morning actually today, came over office from Eviction court. So really, I think it even a more appropriate title, how a bill becomes an eviction, how a bill becomes some of the mental and emotional stressors that Ms. Body and Professor Waring were talking about just a moment ago. And again, it is.
Alex, one quick thing. Do you mind maybe getting a little closer to the
Certainly.
mic? I think we're having
Certainly.
some audio issues.
Yep, I do apologize, and I will speak more clearly. I was having my own audio issues, but and again, I apologize. So Rob, just put your finger up if I'm having issues with my internet here. And again, so my main point is I think the title, how a bill becomes a lawsuit, actually might be a little generous, because what I see in my courthouse here in Hamilton County, Chattanooga, Tennessee, as a small claims court judge who also has misdemeanor criminal jurisdiction, who also has jurisdiction over eviction cases, I see a lot of the same folks on all sides of my courthouse. People from misdemeanor court to eviction court to small claims court. So again, I think a lot of these subjects are all related. But to hit the high points of your question, that Aspen does a great job recapping in its paper. Typically what we're going to be talking about today is actually often, pretty small, relatively speaking, amounts of debt, ranging from $1,000 to $10,000. But this consumer debt, oftentimes medical debt, credit card debt, that's what we're going to be speaking about today. This debt kind of comes about in a myriad of ways. So we'll take, I guess, credit card debt or any other loan type debt or secured debt that you actually, or unsecured debt. You will typically have agreement made with, obviously, a creditor. And when default on that agreement is made, typically the process is that creditor attempts to collect through some internal processes. Then that debt actually might be sold to a debt buyer or turned over to a collection attorney. And that's when it ends up in my court, oftentimes. But even before it ends up in my court, that collection attorney, that debt buyer, might undertake its own collection activities by way of mail, by way of telephone communication, email in today's world, text messages. That communication can often last up to a year, even before somebody might come to court. But after those collection activities are unsuccessful, then what we have is, as we've described, typically a small claims lawsuit that is filed in your local jurisdiction, your local small claims court. After that lawsuit is filed, ostensibly, it's a valid lawsuit. I say ostensibly because, as Aspen has described and as I see every day, oftentimes that lawsuit should have never been filed at all. That plaintiff or that collection attorney does not, in fact, have a good faith basis to file that lawsuit. There is not proper documentation upon which he or she might even be able to win if that lawsuit goes to trial. But we'll put a pin in that and talk about that a little bit later. But that lawsuit is filed. Then what we have, another very, very important point of the process, because it's a point that is often just assumed to occur properly. Again, it's a very big assumption, because then after that lawsuit is filed, service of process must be perfected. Every state has their own, every jurisdiction, local, federal, city court jurisdiction, every jurisdiction will have their own service of process rules, but they're typically fairly similar. You either need to be actually served, actually given notice of this process, or there's some other sort of constructive service where legally there's a kind of a legal fiction out there that defendant actually received some sort of notice of that lawsuit. After that service is perfected, a court date is set. Then you might think, well, let's go to court. We'll let justice prevail. Everybody will approach the bench. Everybody has seen Judge Judy. Everyone will hash out their side. Everyone is on equal footing during that hearing. But again, what I will tell you, even from my work about an hour ago, almost every plaintiff in those eviction cases had an attorney, and almost every tenant, almost every defendant did not. The same is true in consumer debt cases. Almost every consumer, almost every plaintiff, almost every creditor, almost every debt buyer has an attorney present, and almost every defendant does not. But again, that also assumes that defendant shows up in court. A vast majority, I think your research shows across the country, safe to say even upwards of 70% of these cases, there is not the judge-Judy interaction where justice prevails through this adverse proceeding. No, the defendant does not show up and a judge signs off on an award, on a victory for the plaintiff. And because that case is one of 500 on the docket that morning, the judge actually gives a sigh of relief that actually they can move past that case very quickly and move on to the next one. And again, that ultimate lawsuit is never even looked into by anyone. Again, as I mentioned before, that good faith basis to file a valid claim is not even investigated in the least. Whether that person was provided actual service is often not given any more breaths or any more thoughts by that judge or anyone else in the system. And so that 70 to 80% of cases that I see that I grant default judgments or that my colleagues grant default judgments every day, that judgment becomes a legally binding collection tool to add to that creditor's arsenal of collection tools. And it's one that's very important. It's one that we're going to talk about a lot later in the program because it gives it's even more ammunition for more even aggressive tactics, tactics that could end up causing someone to have to choose between paying a mortgage or their rent. Someone that thinks they have money in their bank account only to find out that it has been garnished, levied, their paycheck has been garnished. Again, so very drastic measures that can accompany this new, very powerful collection tool of a legal judgment. So again, I know there's a lot of issues that we're going to talk about, but again, it's a pleasure to be here, and whatever small insights I can even provide anecdotally, I look forward to doing so.
Wonderful. Thank you so much for that really important context. And let's go to our final panelist, Erica. Do you want to dig in a little bit more on what Alex was saying around folks not even showing up and many of these cases occurring unopposed? How does this happen? And the judge was already going into it, but how is this problematic from your perspective?
Yeah, thanks for asking. I think Judge McVeigh, or Alex, I'm going to try to say Alex, characterized this really effectively of in the Judge Judy scenario, or in kind of how we expect our adversarial court system to work. You have two sides arguing their side of the story, and then a judge that gets to make a decision based on the merits or the facts of the case. But it's absolutely right that in more than 7 out of 10 debt collection lawsuits, the consumer is not in the room. And what happens, as Judge McVeigh described, is a default judgment, which means that no one steps into the shoes of the consumer to make sure that the right person was being sued for the right amount, that the court case was actually filed before it was too late, before it was expired or beyond the statute of limitations, or even that the consumer knew that they were being sued in the first place, right? There's no examination of the underlying validity of the debt or the merits of the case. There's just the plaintiff wins by default. But that default judgment carries with it the exact same enforcement power as any other judgment, even a court case that had gone all the way through to trial. The power of that court order opens up these opportunities for additional enforcement mechanisms. So when our justice system is designed around the idea of everyone participating and only one side is participating, only one side is seeing the benefits of the justice system.
Yeah, and the power of those court orders, can they be reversed? Can they be appealed?
I'd love to hear Alex's perspective on that, but what we see across the country is a real range of whether once someone finds out that there was a judgment against them, which in many instances, the first time that a consumer finds out about a lawsuit against them is because their bank account has been frozen or because their paycheck has been garnished, to be able to seek to remove that default judgment and go back and argue the merits of that case from the start, is a real challenge. And often there's a really short time window in which a consumer has the opportunity to do that.
Gotcha. Alex, could you share more about what that process looks like in your jurisdiction?
Certainly, and again, as Erica mentioned, it differs throughout the country, but typically, kind of a majority rule is that small claims court oftentimes, or in a court of record, a circuit court or a higher superior court, there's typically a prescribed period of time upon which a defendant can appeal that judgment. But again, if you're a defendant, don't have notice of a lawsuit, here in Tennessee, it's very rare that you would know that a judgment's been entered against you in the 10-day window that we have here in Tennessee. So again, if it's outside, if you're made aware of this case, and it does happen, some folks actually know of their court date, but it temporarily, slips their mind, and they quickly realize it after the fact, or when they get in the mail, maybe in the order from the week prior from the court, they might still have some time within those 10 days here in Tennessee to ask the judge to set that aside. I didn't know about it. It wasn't me. It was a different Bob Smith. I don't know what you're even talking about. So again, there's that is one thing, but 9.999 times out of 10, that discovery of that judgment does not come until far after that 10-day period. In Tennessee, after those 10 days have lapsed, that judgment becomes a final judgment. All right, and again, I think in most states, the argument is there needs to be a certain time limit to add, a definite period so creditors can have, be aware, and banks and everyone can have full knowledge upon which to proceed with their business. So that there needs to be some time period, folks will argue. However, that time period is often quite short. Now, let's say they do become aware of that judgment after those 10 days or whatever the time allotted in your particular jurisdiction. That person still could have a remedy. They could still go back to that court. But the burden of proof then shifts from the plaintiff, who otherwise would have to have proven that debt, proven service of process. It shifts to the defendant. So you are a debtor already, as we'll talk about, certainly not a level playing field with how you're approaching this lawsuit in the first place, but you're a debtor who now has to prove that you didn't know what you didn't know. And again, just think about that. I mean, how, and so simply coming to court and say, I never got this judgment that was entered against me 5 years ago, I never got it. I lived at that address, but I was working that day. Well, you would have to bring proof from 5 years ago that you were in fact at work at the time the process server has alleged he served you. I mean, it becomes an enormous hurdle, and it's often quite difficult to set aside this maybe voidable judgment. Again, it's not a void judgment. There has been a proper judgment, and there has been service of process, so it becomes voidable, and it shifts to the defendant to prove that. So again, very, very difficult. Long story short, as Erica mentioned, it's quite difficult to appeal that, to set that judgment aside, and even if there would have been a valid claim, that often does not even get to be heard in front of the judge.
And we're talking about consumers who largely do not have an attorney, right? And these are more than 90% of cases have a consumer that does not have an attorney being sued by a debt collector or creditor who does, who has to both find out about the lawsuit and also find out about the rules that Alex is describing that they would have to engage and articulate in order to undo something that has already been done.
Thank you both for that really important information. Fred, I want to go to you next. In doing this research, it was very clear to us that data on debt collection lawsuits is very limited. Why is that the case? And what don't we know about the magnitude of these lawsuits? And I'd love for you to share more about the work you're doing to help get to the heart of this issue.
Yes. So the shock for me as a sociologist was that there's this thing that's so consequential in people's lives, and we don't have readily available data to tell us where it's happening or to whom. That was the shock. And so one of the things that we decided to do, taking some inspiration from our colleagues at the Eviction Lab and working with a data science consultancy called January Advisors, we decided to set up some extraction tools so that we could go into some of these county court online portals and just figure out who's being sued and where it's happening. Now, at first it sounded as if this was going to be like a really great and fun thing to do. And it's a great thing to do, but not so much fun, because from one jurisdiction to another, there are very different restrictions on how you can go into those portals. There are also sort of inconsistencies from one jurisdiction to another in terms of the kinds of data they're collecting and making available. And sometimes you'll look in and you'll say, oh, it's great they have that data field that they're going to report it. Well, you look in the data field and it's not well filled out. And so there are all these challenges. But even with the challenges, we've started in 5 states and we continue to work on some expansion. We started during the pandemic, just doing the extraction month to month, just to see what was happening. And we were able to sort of match it onto census tract data so that, like a good sociologist, we can ask, which are the neighborhoods that are truly disadvantaged? And what are the other characteristics of that neighborhood that track onto that disadvantage? Which neighborhoods are overperforming in terms of the number of lawsuits that are being brought against them? Where are we seeing disparate impacts? Now, this doesn't tell us enough about why you're seeing the disparate impacts where you're seeing them, but it does tell us where the hotspots are, where we need to kind of zoom in and know more. So that's kind of where we are right now. And we're also doing some other work to do some sort of backfilling of data with various data agreements. So we're busy, but we're also learning and really taking advantage of sort of conversations with a National Consumer Law Center, with Ricard's group over at Pew and others, to really make sure that the resource is something that is somehow useful, particularly for debtors and their advocates.
Such important work.
And if I could add too, so I mean, just again, from the court side, practicing both in Tennessee and Georgia, one of his difficulties in collecting that data, Professor Wary, is that, we kind of think of every state's court system as being this, top down, everybody has a unified Supreme Court, Court of Appeals, trial court, small claims, maybe traffic court. But that is not all of our court systems in this country. Courts like Tennessee actually operate in a non-unified way, an ununified system, to where every one of Tennessee's 95 counties actually has its own data reporting mechanism. One of the counties actually got a computer for the first time in rural West Tennessee 3 years ago. So again, you have to not only deal with the various difficulties of having to figure out the different state systems, but then within a certain state, especially if it is not a unified court system, you will have to look at every locality, how they go about collecting and keeping, if they even do, certain types of data. And in those systems that are not unified, there's not necessarily, the Supreme Court can't really promulgate, there's these rules and systems that every court clerk has to use, because it's not that sort of system. So again, why Professor's work is much needed, but it's quite the project that he agreed to undertake.
Yeah. So a question to any of you four, clearly we need better data, but I also feel like we shouldn't be waiting for the data to take action. Any thoughts or perspective on that? Fred, since you might run into this question more than others, do you have any thoughts to share?
Well, so I think the reality is that we never have all the data that we want, but we have enough to know that something's terribly wrong. And so I think the other thing too that we should think about here is, as much as we're thinking about the debtors and where they're located and who's being affected, and how it tracks to race and income, we should also be thinking about who's suing these debtors. And so in the counties where we've been doing work, we'll look at sort of who are the top 5 in that county who are responsible for the lawsuits. And they will, though they account for only 1.3 or 2% or less than 1% of all of the plaintiffs, they will account for over 50, upwards of 70% of all of the lawsuits. And so a lot of times when people are talking about debt collection, they're thinking about the onesies and twosies, like the nice mom and pop store, and they're just trying to get their money. And they're not thinking about these very large, concentrated, powerful entities. Some of those entities are sadly the municipality sort of, they're coming after you for your local taxes and your sewer payments. But you've got your credit cards, and you've got portfolio and some of the big debt collectors. And so I think part of it too is sort of being able to name who the actors are in this space and how much space they're taking up, and also being really clear about why it matters. And so if we think about sort of our relationship to the justice system, when people are getting these summons to court, it's not just telling them a message about some agreement that was broken with the creditor. The way they're treated in this process tells them something about sort of how they fit, and what types of informal rights and informal forms of recognition they are entitled to. And you can sort of start thinking about the spillover from your court system and from what's happening in debts to other systems. And so you get more systems avoidance. And even though we're telling people, you need to be financially included and you see safe pathways to inclusion for you and your family, they're getting a very different set of messages from these court proceedings about what it means to be sort of included and engaged in formal systems. And so we are sort of undermining family financial security, and we're also undermining a sense of belonging and participation in the demos.
That is so important. Thank you, Fred. Erica.
Yeah, I think what Fred's describing is also points to something that, while there is a lack of data, there are some things that we do know. What Fred's describing are points that we can already see empirically, anecdotally. Other things that we know are that debt collection lawsuits make up, they're the single most common type of civil court case today. So this is a wide-ranging, very big scale that we're talking about, a major driver of court dockets and affecting a very large percentage of the US population. And we also know that the rate of participation in debt collection cases is really low, and that's something that there are no strong policy reasons to support and be excited about people not showing up to their debt collection lawsuits. Creditors want to be paid, consumers want to have a fair shake, public trust and confidence in our court system relies upon people participating in the court case. So while there might be incentives for kind of making cases more expedient and taking up time on a very kind of stretched and under-resourced judiciary, there's not a strong policy reason to encourage people not to show up to their court case. But there's a little bit less data, or there's a little bit of data around how to help encourage people to participate in court cases. So there's one randomized study out of court system in Boston that showed that when consumers received information about their court case that was plain language, easy to understand, encouraged them to take the next steps, they were twice as likely to participate in their court case. So we can see some indications of next steps that states can take. And I think Aspen does a really nice job of describing some of the recent policy steps that states have taken around the country to try to tackle some of these core issues that we do already know about from the data that is available.
It was powerful to hear what makes folks more likely to participate or respond. And Fred, one of the things I've seen you write is how treating folks with more respect and dignity increases responsiveness. So that's a very simple but straightforward principle.
Yeah, and much of it is it goes into the design. And so what Erica just described is there are things that you can do to a letter that have a huge impact in terms of how people respond to that request. And much of that is sort of, we've seen other experiments where people have, so by recognizing that they have some kind of worth, and that they are not abnormal and deviant, and that they probably actually want to pay what they owe, people tend to show up. But when you are degraded, it can be a sort of deactivating for you. And so your ability to act goes down as your sense of worth is being degraded. And so I think one of the things that this brings up is the extent to which sometimes we think about what consumers are doing and what debtors are doing as they just need to follow the rules, and we're not asking how those rules are being implemented in a way that sort of by design is making it less likely that they can follow the rules.
Can I jump in here?
Yes,
Yeah,
please.
just on this conversation of data before you can even get to the conversation of collections. Data on debt holdings can reveal a lot about who can potentially be at risk, and it reveals a lot about historical tendencies as well. And I agree with Fred, it's very much a systems change within the court and litigation system, which I am not an expert about, but also before that, within the financial system, within the debt and wealth holding system. And it's really, it introduces an issue of inequalities and inequities in household debt. And a framing that tends to resonate with people is good debts versus bad debts. There are debts that are typically thought to improve households' well-being and financial standing in the long run, and these can be, business debts, home debts, even student loans, which some people may disagree on that last one. But then there are bad debts that tend to be very high cost for certain households, and they don't seem to contribute much to the long-term financial well-being. And these debts you've already heard by the other panelists: credit card debts, payday and title loans. And then there are non-loan debts, such as past due utility bills, medical debt, court debt, which disproportionately impacts households of color. And we see that there are very stark differences between debt compositions by race. And I'm saying this to just give some historical context, because a lot of these disparities are rooted in historical racism and things like redlining, structural barriers to building wealth, to predatory and discriminatory lending against communities of color. For example, Black and Latinx households are less likely than white households to have debts that support long-term wealth development, such as a mortgage debt. And instead, they tend to carry the high-cost debts that are associated with expenses of everyday life. But again, medical debt, municipal fines and fees, utility bills, and these are the debts that are most likely to end up in collections. So I'm really glad to hear that that people like Fred are doing the work to not only understand it before it gets to the collections, who's at risk, but it sounds like Erica and Alex are also doing the work to better understand the systems once people are in the court system. One proxy that we look at is secured versus unsecured debt holdings. We recently looked at debt prevalence by race, and again, the number one observation we came out with was that white households had more secured debt than Black households in every single category: business, home, vehicle, whereas Black households had more unsecured debt than white households in credit card, medical, other types of debts that are likely to go into collection. So it's just really important to highlight, who is at risk and why. And then I think the last thing I'll say on that is that households with high debt burdens, that's more related to income, how much debt you're holding in relation to how much income you're bringing into your household. That also is a very important factor that just starts a vicious cycle of destabilization. And it gets harder and more expensive for a person to catch up to a debt, which then leads them to involvement in the court systems, which is very harrowing from what we're hearing, from what I'm hearing from the rest of our panelists.
Absolutely. Thank you, Devon. And Devon, I wanted to ask you a few, because I know you also do work around housing and evictions. Do you see parallels between debt collection lawsuits and evictions, just given maybe the similar stigma and toll that they can have on households?
Absolutely, absolutely. The mental, first of all, the mental and emotional toll of interacting with the court systems is just another conversation in itself. The mental toll can have very traumatic effects in the long run on a family. And I think household instability and debt also go hand in hand. We've seen this throughout the COVID-19 pandemic with the eviction moratoriums. So people were collecting past due rent that they could not pay because there were people who lost their jobs, could not pay for their housing. And instead of having to go into the court system and be evicted from their homes, luckily, thankfully, there were moratoriums in place to protect those households that were most vulnerable. But it also connects in other ways. We recently released a report in partnership and collaboration with the Housing Initiative at Penn, and they had previously done a study over the summer with the state of California. They did a renter survey, and that renter survey found that on average, households collected about $3,050 in debt to pay rent, but this isn't their rental debt. This was additional debts that they took on that were credit card debts, payday and title loans, and informal debts such as borrowing from friends and families. And this type of debt is not included, is not being reimbursed by rental emergency assistance programs. So this is called shadow debt. So in my opinion, it goes very hand in hand, just in the relation to involvement in the court systems.
Absolutely.
And I'll add too, just again, a great example from about an hour ago when I was in eviction court, is that in addition to, Ron mentioned the moratorium as being kind of a godsend for a lot of people. And then some folks might also have recalled the vast amount of federal dollars and state and local dollars that were allocated to tenants and landlords to, again, try to keep those debts from really accumulating during that moratorium. Now, the problem is that out of the about 15 pro se non-attorney cases that I had on the eviction docket this morning, almost none of those tenants had undertaken the steps, or landlords for that matter, necessary to collect any of that federal funding. And again, and I think and I know Devon probably knows, and Erica a whole lot more about the ways in which that money was dispersed amongst the country, but it was dispersed and is being distributed in vastly different ways. Some localities have set up disbursement centers and are far more active at their local courts and before going to court. But in my locality, they rely on HUD and they rely on the state of Tennessee to actually some of that assistance, and it takes work on the part of the landlord and the tenant to receive those monies. So all the folks that were in court today, even though there was this moratorium, even though that there is this federal assistance that people assume are just flowing down to the landlords, keeping them in tenants in good standing with them, that is not the case for the majority of the evictions that I presided over.
Gotcha. One thing I've seen in the chat, and this was a suspicion of our team as well, but do folks here suspect that the impact of the pandemic and the end of this moratorium, the surge in medical debt, do you expect to see a spike in debt collection lawsuits in courtrooms across the country? Erica, I know you have a pretty national view. Is this a fear that you might have or something that you're anticipating?
We've been talking about shadow debts, but there's also a conversation about the shadow docket. So thinking about cases that would have been filed but haven't yet been filed because of challenges that people have had with courts being closed or their own ability to file cases. And what we've actually seen so far with debt collection lawsuits is that after a small dip at the start of the pandemic, they've been trucking along. They've been companies that are familiar with using the court system have been able to identify ways to continue to use the court system. And that also has pointed to some of the efforts that courts have made, really heroic efforts to try to keep courts open and functioning during the pandemic, have also meant that there's electronic pathways for how you can file a court case and how you can move forward with your court case. And those companies that file high percentages of court cases, namely debt collection lawsuits, have found those pathways pretty effectively. So we've seen a steady increase or a consistent rate of debt collection filings even during the pandemic. And I think the next question will be to see how the financial distress that families are facing plays out in the court system, because the data that we have largely is from times when the economy has been strong as well as weak. And even in the times when the economy has been strong, families have still faced a really high number of debt collection lawsuits in the courts.
Super helpful. You mentioned electronic filing, so I think this is a good opportunity to hear from Alex about some of the innovative work you've done around online dispute resolution and electronic filing. I'd love for you to share the story of the work that you've pushed for and the pilots you've pushed for, and to share what you've learned so far.
Certainly. Kind of piggybacking off of one of the things that Professor Wary talked about earlier, when the system is plainly described in plain language, when resources are made most easily available, we've seen that folks actually do participate. And again, so with that mindset, we approached one, electronic filing and dispute resolution throughout Tennessee. The Tennessee Supreme Court allowed for, during the pandemic, free mediators for every single civil case in the state of Tennessee during the pandemic, including all claims collection cases in General Sessions Court, which is my small claims court. So in addition to attempting to provide these additional resources to solve some of these disputes, I guess, adjacent to the court system, we thought here with the high prevalence of medical debt actually in my community, and there was a white paper done by a partner at Sycamore Institute in Nashville talking about Tennessee has been one of the worst places, and this is pre-pandemic, for medical debt per capita. We attempted here in my community, Chattanooga, one of the one trauma centers here in southeast part of Tennessee, being again a high medical debt caseload for some of the plaintiffs here. We attempted to come up with some sort of dispute resolution system that again would be very easy on a debtor, would attempt to resolve disputes at the lowest cost possible to the provider and the debtor. And we had this idea to potentially do it before attorney's fees, court costs are all added on to a particular case. Because again, if you think about it, a lot of collection attorneys work on whatever they collect, they get a third of it, or they're charging a certain percentage of attorney's fees based on the debt, or a certain or at their actual cost. So you get a $5,000 debt, and all of a sudden you've added on $3,000, $2,000 to that debt. It has transformed the case for this particular defendant, and they might agree to resolve it when again they had a legal defense, just because the costs are getting out of control. So we thought, what if we designed a system that interacted with a particular debtor before the filing of a case, kind of a pre-suit online dispute resolution system. And there are not many throughout the country. There certainly is a lot of online dispute resolution throughout the country currently happening. And I know the state of Utah, and I know there's quite a few private online dispute companies out there working in various jurisdictions. But we attempted to try something a little bit different here to attempt to tackle this problem of massive amounts of medical debts and medical debt lawsuits here in Hamilton County, Chattanooga. So we partnered with the Supreme Court here and some great partners nationally who provided funding for this online portal that easily allows providers and debtors to negotiate, whether it's at midnight when a debtor gets off their second or third shift job, but it allows that person to interact as easily as possible with a provider. And again, at this point, that debtor has ignored that provider for their cycle of the collection activities that typically happens. But we are seeing some amazing early results in some of our testing, where folks that have been, radio silent debtors are now actually coming to the table and interacting with these providers to resolve this dispute. But again, it's very important. One, I know we're getting short on time. One, we want to make sure that with any of our solutions, including those that were proposed by Aspen in its policy solution section, we want to make sure that one, we are not allowing debtors to necessarily affirm or create new contracts when they might have had a legal defense or they don't actually owe the debt. So you want to make sure, we have made sure that our local legal aid organizations have been intimately involved in the creation of this platform. Two, we want to also make sure there's a trusted third party that's somehow involved. And so again, this isn't meant to be just another collection tool for a creditor, for a hospital. So the Tennessee Supreme Court has provided free pro bono mediators who are licensed and trained by the state to actually step in and attempt to mediate and resolve these disputes, again, before a lawsuit is filed. We have designed the software. We are testing it. We've had quite a bit of early success, and we hope to have more. But again, it's one of these ideas about what are some ways that we can think a little bit outside the box to keep costs down, to try to meet folks where they are and attempt to allow this resolution in a less stressful atmosphere and environment.
Really great work. Erica, I know you're also close to looking at online dispute resolution solutions. Anything you want to add to what Alex was sharing?
Yeah, absolutely. And I think some of the conversation in the chat has been around some of the protections that Alex is describing, which is a really thoughtful part of the model in Hamilton County, is to be not just thinking about replicating existing court processes into an online tool, but to be thoughtful about who the users are and what rights need to be protected to make sure that those are all being built into something that is meant to make things better rather than just kind of exacerbate existing inequities by moving them into a new technology tool. And I'm also excited about the fact that it's before filing, which is something that we haven't seen very much of around the country, but it's a really interesting idea for the court to be kind of the owner and sponsor of this process for people to be able to come to a resolution, but without it being a fully fledged court case that comes with a court judgment and all of that sort of enforcement power at the end of the experience.
Gotcha. And could you share why ODR alone isn't the only solution we need here?
Absolutely. So we're seeing right now kind of a range of different applications of technology for court cases, but the challenge that a lot of jurisdictions encounter, whether it's when they're moving to online dispute resolution tools or other technology innovations, is that the underlying policies and processes that they're working with are themselves inadequate. So we've talked already before about kind of the inability of a judge to step into the shoes of a consumer who's not participating in the court case to make sure that the case was valid. That's not going to be fixed by a technology solution necessarily by itself, right? That's going to be, technology could certainly help, but is best when it's undergirded by an actual look at the processes themselves and the policies in place and what can be reformed there that the technology is leveraging.
Really helpful. Well, I know we have just about under 15 minutes left in the webinar, so I did want to give you all an opportunity to weigh in. We've talked about a lot, but are there any recommendations that you want to pose, whether these are policy ideas or areas that we need more research around? And this could be where we've been focused so far around the lawsuit process and phase, or it could be thinking of solutions upstream, but would love to hear any ideas that you want to seed with this audience today.
I'm happy to start. I know the Aspen does a great job of talking about some ideas that can happen both at the federal level, the CFPB, and some other rules and regs that could maybe happen more quickly than somewhat arduous state rule change process when it comes to state rules of civil procedure and Supreme Court rules. But in addition to those, both the state policy proposals and the federal policy proposals. I'd like to add, if you are in a particular jurisdiction and are having difficulties, or you see in an area that there's some difficulty in making any sort of mindful reforms, these reforms could potentially happen at the local level. And what I mean by that is let's say you can't change the rules of civil procedure concerning process servers in your state to require photographs or require GPS, sworn statements. Well, what you could potentially do is meet with the local jurisdiction. And local jurisdictions often have the ability to promulgate local rules. So that local rule, like one we are talking about here, is if the state won't change the procedure concerning service, well, we can require our process servers to go through a training class that is put on by the judges here. And in that training class, we can stress to them that we will require certain proof, certain sworn statements or live proof when it comes to service of process, so that we are sure that this person is who was actually served and is who the debt belongs to. So you could potentially even look even more locally than what was some of the great ideas that Aspen proposed in its paper. So I guess I just would think I would just challenge folks on this call, particularly those that are interested in moving some interesting policy ideas forward. Don't necessarily stop at the federal level or the state level. I mean, look to local jurisdictions, local municipalities, local small claims courts, local judges. See if you can meet with somebody that might agree. There is nothing stopping me from standing in the shoes of the debtor that's not there, as Erica mentioned, and making sure there is a valid claim upon which I can enter a default judgment. There is nothing stopping me other than the 500 cases I know that I have coming up next. But again, so if you're having trouble affecting change or getting folks to listen to your ideas, I challenge you to look even more targeted, more locally.
Suggestion. Fred, I don't know if this is going to be the idea you tee up, but I've been really compelled by the concept of a dignity assessment that you raised in the Future of Wealth book, but not sure if that was what you're going to jump in with, but would love to hear your thoughts there or elsewhere.
Yeah, so just as the judge talked about these trusted third parties, and one of the reasons that you trust a third party is because whenever you have contact with them, they sort of treat you as if you are worthy of their time, and you have a sense that they have your well-being in mind. And so with that, thinking in those terms, if you had a better sense of what's happening at the points of contact between debtors at all stages of an attempted collection, we might be able to ask better questions about some of the tactics that are meant to kind of spur debtors to action, and might just sort of make it much less likely that they do anything productive. And so just as we would want to make sure that we're not being abusive to someone who has a medical issue when they show up to an emergency room, people who are in an emergency should not feel as if they're going to be faced with abuse by people who have the power to somehow engage with them and perhaps even help them. And so in this way, I think we have to start really thinking seriously about what's happening at these points of contacts. What are some of the codes of conduct that really should be considered standard for how you treat people, even people who don't have money.
Very well said. Devon or Erica, any thoughts you want to share with the audience as we get close to the end?
I'll jump in. We moved from talking about the lack of data about these things to solutions that we should still be engaging in the absence of data. And I think those are all valid. And I think being able to hold up models like the states that are called out in the Aspen report, I think is a helpful start. I don't want to give up on the data point, though. I think it's still worth pursuing, understanding more what's actually happening in our court system. I think we have a right to know. I think as courts seek to engage with the public, it's a mutual interest for courts and policymakers and the public alike to know what's actually happening in the court system and to be able to understand what changes we'd like to see collectively. So I'm at Pew, we're eager to work with states and local governments, as Alex was describing, to unpack their own data and examine what's happening and how their policies are playing out in the court system and outside of the court system. So that's definitely a place I would start, but I'm also interested in consumers, financial services folks, members of the public asking these questions of their state.
That's great.
Yeah, I would just echo what Erica is saying and give a friendly +1 to the solutions that Fred and Alex also mentioned. Just speaking at a higher level, where my opinions represent my own, but I'm always asking what mechanisms in the debt space are not working for people based off of people's lived experiences. I'm always asking myself, how can we better leverage good debts and better manage bad debts? It's really a question of optimizing use for households who are lower income, low to moderate income, households of color, and a portion of those answers lie within the system. So I'm honored to be on this panel and to be hearing about these different solutions. And I also turn it back to our audience to be answering these questions as well. And I was recently in a housing roundtable, which again, so many parallels, but one quote that someone said that resonated with me is that people in need often operate in a different banking system, a different credit system, a different paper system, and yet we are devising programs and processes that don't connect. So program design must meet the realities of people's lived experiences and respect them as well. So I'm always of that mind, and very glad to be hearing about these different solutions from the panelists.
Wonderful. That was very well put, Devon. Thank you. Thank you, Fred. Thank you, Erica. Thank you, Alex. We really appreciated your expertise. I know in some ways we could only scratch the surface on all the questions we had prepped for, but I think this was a really helpful conversation for our audience. And thank you all for your commitment to this issue and a commitment to financial security for folks across this country. So with that, we appreciate your time, and feel free to turn off your cameras and wave goodbye if you'd like to the crowd. Thank you so much. Well, excellent. Once again, major thank yous to all of our panelists. A thank you to any Casey Foundation for supporting this work. And a major thank you to everyone who was able to attend this report. Our call to action to you is to please dig into the Aspen Institute's recent report. We'd love to hear from you about our policy recommendations there. We also encourage you to look at a lot of the links that were shared in the chat today. We will make sure that we follow up with some of those links to you afterwards. And we really encourage you all to continue to play your role, thinking about these issues seriously as our panelists recommended, and to push for reform, either along the lines of our recommendations, some of the ideas raised on this call, or wherever you may see opportunity in your communities. For this report, we focus on just this very specific phase of the lawsuits, but there are plenty of opportunities upstream to create more dignity and respect for consumers. As we say, there's a lot between the doctor's visit and the courtroom. So we hope those of you in your disparate roles, whether that's asset building, private sector, public interest, really found something valuable today. And we ask that you continue to share what you're learning, what you're hearing with this community and the broader communities around you. So once again, thank you so much, everyone. A quick plug, on November 10th, the Aspen Institute's Financial Security Program will be back again with another webinar along with Springboard to Opportunities. The topic of that conversation will be benefits over burdens, policy-making lessons from the expanded child tax credit. The discussion will provide insights for policy design from the perspective of families these policies are intended to serve. We'll also discuss the CTC expansion as a use case for these insights and how policymakers can apply the lessons broadly to building a modernized system of benefits. Well, with that, we're going to wrap up the programming. We will once again share some of the artwork that we started this powerful conversation with, and we hope that you continue to dig into this topic and explore some of the great works of our panelists today. Thank you everyone for your time. Take care.